Thank you so much. Thank you very much, Ben, for the invitation and for the kind introduction. Super excited to be here to present our study on benchmarking legal reasoning. And so this current project presents the first paper of the larger project that we are collaborating with Ben and many other excellent researchers here. And so the study was motivated by the fact that many studies 2 years ago show like large language models like ChatGPT aces law exams. And when I saw this news, my question was like, this surely cannot translate into real world in the sense where people need like real assistance from practical legal cases. And as it turns out, 2 years later, this is a very new article says that this is actually the case. So many legal practices are being replaced by off-the-shelf tools such as ChatGPT. So still, it remains a big question because the current benchmarking research does not really show to what extent these reasoning steps are being evaluated. And that motivates our study here. And more particularly, so the first point that the first motivation is that we believe that legal reasoning is a very important yet underexplored field in AI. So for today's audience, I think it's not really necessary to explain why legal reasoning is important. It requires like general skills such as advanced analytical skills, but it also requires legal knowledge that are domain specific. So then that's why we believe this is an ideal testbed for testing non-formal reasoning, as opposed to other generic fields such as math and coding. And as Justice Holmes once said, the life of law has not been logic, it has been experience. Of course, Justice Holmes did not intend to criticize reasoning based on math and coding, but it shed light on the current development of legal reasoning optimization on large language models, because for a model to be able to conduct legal reasoning, it needs not only the formal logical skills, but it also needs the knowledge about the world. And the second reason that we want to do this study is based on the fact that there are already several benchmarks datasets available in the research community, such as Legal Bench and Law Bench, and so on. But these previous benchmark datasets for legal reasoning has at least two major drawbacks. So one is like they are purely based on an evaluation of the final outcome. So a model is able to provide legal reasoning, to conduct legal reasoning if and only if the final answer of certain questions is correct. And of course, this way of evaluation neglects the intermediate reasoning steps, which is the backbone of the reasoning part. And the second problem is some kind of a tax proficiency that are built for these kind of data sets where tasks are formulated as some kind of very artificial settings. For example, like a legal judgment prediction, where you are given a case facts written by a judge, and you are asked to decide what kind of a decision you can make based on these facts. So this is artificial because as a legal practitioner, you will never be given a fact that is written or summarized by a judge and then asked to decide, right? And of course, this kind of information can still provide some information about the legal reasoning skills on a very specific perspective, but it lacks some comprehensiveness of this evaluation setting. So to solve this problem, we develop a new data set by this generation pipeline. To solve the problem one, which is purely outcome-based evaluation, we gather the question of free-form textual essay questions from law schools, and then employ LLM-as-a-Judge to check the individual reasoning steps written by legal professors. And to solve the problem 2, which is data artificiality, we use real law school exams, where we gather domain-specific metadata like the courses and legal domain subdomains and so on, to provide finer-grained information about in which perspective the reasoning are well versus badly conducted. So this is roughly the summary statistics of the data. We have more. The data are collected in Swiss law schools. The current version are based on the largest law school in Switzerland, which is the University of Zurich. And we have more private law questions and public law questions, a smaller amount of criminal law cases, and very few courses that derive from interdisciplinary courses, such as legal sociology or legal philosophy. And because of the first batch of the data coming from Switzerland, most of the cases most of the questions are written in German, and we have a smaller amount of questions written in English, which allows us to make a cross-lingual comparison. And most of the questions are related to Swiss jurisdiction. And a sample open question looks roughly like this. So you are given a bunch of legal facts, and you are asked what kind of legal relationship can be determined based on the facts given here. And reference answers are written by the law professors of the individual courses. And without giving this to the model, we ask a large language model to answer the question based on the question stem. And then we employ a judge language model to compare between the reference answer and the answer generated by the models, to give a evaluation on the skill of this large language models in reasoning. And a sample MCQ looks just like a kind of a conventional MCQ questions, where you have also a question stem, and you have a bunch of statements that are either correct or incorrect. And we shuffle the ordering of the statements from the original question to make sure that this original question has never been seen by any of the large language models before. And we keep the correct label here for each of the statements, integrate into an option here, and then randomly generate 3 wrong answers. By the way, if you have any questions or if you would like to share any insights, please feel free to interrupt anytime. And so these are the main results that we collect. So if we look at it from the bigger picture, general reasoning models actually can do a reasonably good job on legal reasoning. So reasoning models refer to the models that are trained specifically to conduct reasoning before, like generating thinking tokens before generating the final answer. And traditional large models are the models that generate that are not optimized using methods like RLBR or other optimization methods. The smaller models are also like traditional models here. So it seems like the reasoning optimization in generic domain does help in legal reasoning. But if you see this, if you zoom into like specific performance of different model families, what you can see is like a plateaued effect. For example, the Claude 4.5 model, that is a newer version of Claude 3.7, actually does a worse job compared to the earlier version, even though they are claimed to have a huge improvement in other domains like math and coding.
Could I just pause you
sure.
and ask, how do you get the standard errors? So for the benefit of the audience, because oftentimes you do evaluation, you don't necessarily get a standard error. So you're doing comparisons here and your standard errors. How do you compute the standard errors?
We do the bootstrapping. So we calculate the standard error by bootstrapping 1,000 times for calculating each the difference of different batches. Is it okay? Yeah.
think some of our PhD students might not understand what bootstrapping is.
So you basically randomly choose your subset of the examples to calculate for each time, and then integrate the results together for different batches. And this allows you to have an estimation of the uncertainty based on because of the specific sample you have compared to the real world in the sense. And also like Quinn models, the newest model that we tested is Quinn 3 next. And you can see that even the older models like QWQ and so on can do an even better job, despite the fact that they are older. And to see whether or not our two data sets or two part of the data set, that is the open questions and the MCQs, have a aligned result, we test the ranking of different models in each of the settings. So what we see here is roughly what we call is like Anna Karenina principle that basically says all strong models are alike in the sense. That is, the models that are good at open questions are also good at MCQ questions, which also applies basically to the larger models. But if you see the smaller models, you see a lot of crossings between these two groups. So this basically means that the smaller models are more susceptible to the way you ask the questions. So basically, even some changings of the prompt could lead to a decrease of the performance, as I will show you afterwards. And so the main results also shows that language plays a role in the legal reasoning, which is not very surprising to me. So the German questions are harder to answer, which might be due to two reasons. The one is that the German courses are more likely to be the core courses for lawyer training in Switzerland, and versus English courses might be more likely to be the courses from like international LLM programs, and which might be easier. And but also it's the case where it echoes the studies from other research groups, where they also show that non-English legal reasoning remains more challenging compared to English because of lack of representation of the data. And in the legal area, we see that for me, somewhat surprisingly, private law is actually easier in MCQ-based evaluation, but it remains a quite challenging part in the open questions. So if you constrain the options of possible reasoning paths, like in the MCQ settings, it shows that maybe private law could be an easier part of the reasoning. But of course, this is a question that I have to that I would love to discuss afterwards, whether or not this whether private law professor would agree on this. And we also show that jurisdictions play the role. Swiss law remains more challenging compared to international courses and generic courses. We did some kind of perturbation on the MCQs to show that whether these questions are whether models just are able to answer these questions because questions have been seen somewhere in the internet, or they are doing genuine legal reasoning. What we should do here is like to flip the questions polarity by choosing the questions that are asked positively to questions negatively. So as you see, this becomes a huge challenge for the models. That even the strongest, even the reasoning models, has a huge drop on this question polarity. Also, if you can include some kind of distractor options like none of the statements in your option choices, you see that including this also leads to decrease of the performance. And to do some further perturbation on the MCQs, we choose the questions where there are at least 5 statements here, and we control for the question stem and the statements, and then generate choices with one correct answer plus 3 wrong answers versus 1 plus 7 wrong answers, and so on and so forth. This is to mimic the situation in the real world where if you take the exam, you are not given the information of how many of the statements are correct or not. And to some extent, the 32 choices should actually reflect the real difficulty of the questions of a human exam taker. What we show here is like there is a huge decrease as we increase the candidate choices, and it's even for the strongest models like Gemini 2.5 Pro, the decrease is pretty substantial. What is more interesting is to show that models like DeepSeek V3 has the strongest decrease compared to other models. So in the 4-choice setting, the performance of V3 is roughly slightly worse than 2.5, but in the 32-choice settings, the difference is more than a half. So we argue that this is the harder questions might be a better way to differentiate between models of different capabilities. And so what the results that we showed earlier is based on an assumption that we can faithfully evaluate the results based on a large language model as a judge. But the literature shows that there is one potential issue for this approach. So if you employ a large language model to judge the results automatically, they might present some kind of self-bias or family biases. That is, they might provide a higher grading of the models of their own family. For example, in this table, we test whether or not this is really the case for 3 models as a judge: GPT-4o, V3, and Queen 3. And underwaved lines shows that, for example, here at So for example, the GPT-4o, when being used for grading results generated by GPT-5, it is the robust compared to other models. And the Queen model provides the best scores for Queen models as well. So this really, they do have this kind of a family bias. To solve this problem, we developed a method to ensemble these results. That is, we we deploy basically the 3 models together and ensemble the results based on point-wise minimum score. For each of the question, we ask the 3 models to generate a score, and then we pick the minimum one. That's when a model shows present self-bias, the score will be excluded from this method. And we evaluate the results based on a method called alternative annotator test. That is, we basically want to compare the evaluation of a large language model against 3 human experts. So we point-wise, we remove each of the human experts using a model and test whether or not this LLM judge's distance to the mean of the remaining 2 experts is larger or not. So if it's closer to if the distance if the distance of the model is smaller than the human, then we count this as a winning case for the model. Otherwise, it's a winning case for the human expert. So what we show here is like we have results based on the ensemble model versus 3 legal experts, and we have a winning rate of 1, so 100%, meaning that we can faithfully replace legal experts in this specific evaluation with statistical significance. And we also compare against other standalone models and other ensemble methods, which shows our method strikes a balance between cost efficiency and utility here. And to conclude, we developed a new legal reasoning benchmark that incorporates both process and outcome-based evaluation. And we base our results or assessment in specific legal domains, which allows for finer-grained comparison of different legal areas. And we employ an ensemble large LLM as a judge with expert validation, which allows for consistent and accurate evaluation of model-generated legal reasoning steps. And of course, we have several limitations, one being the temporal validity and legal updates. So laws, especially in the public domain, public laws, may evolve very fast. And this fast evolvement may lead to certain questions not valid anymore. So after a certain period of time, models may be penalized by incorporating new laws, which could be a potential limitation of the data set. And also, like, we based the reference answer on a answer written by a professor who consider the answer to be the perfect one in his mind or her mind. And this could be also a potential issue if you you encounter a very creative student model that can generate alternative answers that are different compared to the reference one, but are equally valid. And based on the reference answer, we cannot evaluate this kind of results. So as a further step, we are currently developing a second version of the dataset together with Ben and other researchers, where we want to include more jurisdictions and develop new evaluation methods like using rubrics that takes into account the diversity of the valid answers, the time shift, and the questions of the answers that incorporates capital sins versus smaller sins, and so on and so forth. So we would greatly benefit from your contribution if you are interested, and feel free to contact us, and it would be great to collaborate in this joint venture. And thank you very much for the presentation, and I look forward to any questions and comments on this.